So thank you so much for agreeing to talk to me today about the False Claims Act. Can you introduce yourself and tell us where you work?
Sure. My name is Julie Bracker. I'm a False Claims Act attorney based in Atlanta, Metro Atlanta. My partner Jason Marcus and I are here, and then we have an attorney in DC, an attorney in New York, Manhattan, and then an attorney in Kansas City. So we practice in the False Claims Act space all across the country and have been our firm has been around since 2015. I've been doing this and only this since 2005. So I'm officially a one-trick pony.
You only do False Claims Act stuff.
We only do whistleblower. So we do have some SEC whistleblower, which may increase given the recent rules that have come out for the SEC around the cyber reporting. But we've had a few IRS whistleblower cases. Those are very different programs. And then we also have we do primarily federal false claims, but a lot of the states also have False Claims Act statutes. So we have, I'd say, yes with an asterisk. How's that?
Can you tell us what the False Claims Act is specifically? I know there's lots of people everywhere who talk about what it is and what it isn't. Can you give us like a succinct thing that people need to know about what the actual False Claims Act says?
Sure. I'll give you a succinct thing and then I'll carefully try not to get into geeky, super boring to everybody else stuff. But the Federal False Claims Act is what the federal government calls its primary tool for addressing the knowing misuse of taxpayer funds. So more than $65 billion have been recovered under the False Claims Act. And the basic gist of it is if you have knowingly submitted or caused to be submitted a claim for payment to the government that was you knew was false when you made it, and I'll talk about what knowingly means in a second, then you are subject to the act. And that means that that money can be recovered at treble damages. And for every claim you filed asking for money, you are subject to civil money penalties in an amount that per statute range from $5,500 to $11,000, but that's been increased by inflation. It's tied to the inflation. And so I think it's up to 13 on the top end now. I don't keep up with it. It's dollars and cents, but that's mandatorily issued by the court if you lose at trial. So the civil money penalties is another aspect of it. So I said it's knowingly presented. That's actual knowledge as you would understand it. I actually knew this was false when I told you. Or you can you can have deliberate ignorance. I chose not to know, and then reckless disregard. So any of those would classify as knowingly. The idea being that you can't just put your head in the sand or, na 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 na, file a claim and not know, not choose to know that what you're filing should not be compensated for under the act. So that's as succinct as I can get it. I'll say that when I'm talking to potential clients, we talk about the fact that if you've lied to the government to get money, or you've lied to the government to keep money you're not entitled to, or you've lied on something that caused somebody else to get money they weren't entitled to, then those are the situations where you may very well be subject. You may be looking at a False Claims Act case. So
Okay. And I want to talk about whistleblowers specifically because those are your potential clients. So before we get into why specifically you and the defense industrial base, can you share why whistleblowers would be incentivized to come forward?
absolutely. One of the very unique facts about the False Claims Act is the qui tam provisions. So I'm going to drop some knowledge on you, Leslie, that it's qui tam, not qui tam, even though we've all studied French and we've all
I Googled
Spanish.
it because I didn't know that when I read your filing specifically, I Googled how do you say it and I found a YouTube video that said no one knows how to say it, but this is how I say it. So,
Yeah, I,
Etam.
I, I take a hard line. It's
Okay.
qui because it's Latin. So it's a big long Latin phrase that means he who sues on behalf of the king and himself or the government and himself. And we have quid pro quo in Latin and we have no problem saying qua, right? So it's qui tam. Because I'm Southern, you could also say qui tam if you prefer, but it feels a little pretentious to me. So I go with qui tam. In any case, the qui tam provisions say that if you have witnessed a fraud on the government, as we just described, then you can bring that information to the government in order for the government to recover, and then you will receive a percentage of what is recovered by the government. So that percentage ranges depending on whether the government intervenes in the action or doesn't, and I'll kind of come back to that in a second, but that percentage can be from 15 to 30% of what the government recovers. So if you look at it from just a statutory construction point, the idea is somebody steals from the government, they pay it back times three, and the relator gets to up to 1/3 of that. So even if the relator recovered a third, the government is still getting double damages back, and it's all coming from the bad guy who took money from the government in the first place. And then the defendant is also required to pay attorney's fees, which is an interesting discussion when you get into trying to settle this, because under the False Claims Act, you have a claim for attorney's fees, you have the claim for the government, and you often also have a claim for the whistleblower who's been retaliated against. So if they are retaliated against for trying to stop the fraud, and that even it's not so much because it used to be, but it's not so much because they filed a qui tam, it's because they tried to stop the defendant from engaging in the fraudulent conduct. Then you can imagine that doesn't go over very well sometimes, and people get pushed into lower jobs. They get, sunk on their performance review. There are just a lot of things that can happen, up to and including termination and blackballing, that happen to relators when they try to bring these things forward. Which would make you ask, why would anybody do this? Why would anybody bring this forward? And a lot of my clients, especially those that come from a procurement or defense contracting basis, it's concern for the soldiers. It's concern for the taxpayers always, and then that the government is paying out this money that it shouldn't be paying out. But when defense contractors cut corners in a way that endangers soldiers' lives, then you can bet we'll file the case, even if it doesn't meet the threshold we normally would have as far as the amount of information the relator has, because I want the Department of Defense or appropriate agency to take a look and make sure that there's not any safety issues. And these folks are putting their lives on the line for our country. The last thing we should be doing is short circuiting or shortcutting the tools that we're giving them. So
Yeah, speaking of the Department of Defense, so you have a client who was pulled out from under seal last year, and then I think you have some news that you could probably share that's not. There's been no public announcement about it, but it is not under seal anymore. So this is kind of like breaking news
yeah, it's
about
great news.
the False Claims Act and the DoD specifically. So can you share?
I can. I'll back up a little bit and say that in 2021, the Department of Justice announced its Civil Cyber Fraud Initiative, and what I say it said, which is a little bit aggressive from what the main justice folks would say, is that it basically said that when you don't take care of your cyber housekeeping, UI information or other ITAR information, classified information that should not be, we don't want to be accessed by threat actors. We don't want it to be in the public domain. It's critical to national security. The department announced that it would be using the Federal False Claims Act to enforce these contractual provisions where Brian Boynton, who was at the time the acting, well, still is, I believe, he's the acting assistant attorney general for the civil division at Main Justice, announced that there are basically three types of situations where the government would be using the federal false, and not exclusively three, but at least three situations. One would be knowing failures to comply with cybersecurity standards. So, the government might be purchasing a package that's going to be implemented across assorted agencies that purports to keep information secure, and maybe it doesn't. Knowingly doing so would be a violation of the False Claims Act. So an example might be failure to restrict information from non-U.S. citizens for certain portions of the information. The second flavor of this would be a knowing misrepresentation of your security controls and practices. So, and again, we're seeing that word knowingly. We're not after the companies. The False Claims Act is not setting out to catch people who are negligent. It's something more than negligence, but it does, with the Civil Cyber Fraud Initiative, it pushes companies who contract with the United States, especially in the DoD space, to be aware of the fact that this is not something you can put your head in the sand about. We are counting on you to take care of your cyber obligations and keep our information safe. So a knowing misrepresentation might be, if you contract with DoD since January 1st, 2018, you've been certifying that you're compliant with the NIST standards as set out in the Defense Federal Acquisition Regulations. And if you've been certifying that you're compliant and you're not, that's a knowing miscertification under the False Claims Act. Similarly, if you enter your number into the SPUR system that gives where you've done a self-assessment and given yourself a score that's inaccurate. Maybe you put it in and didn't know it was inaccurate, but you come to discover that it is uh, overstating your compliance. You have an obligation to correct that, or I say you have an obligation to correct that. I'm sure I have colleagues on the defense bar who would maybe take issue with that, because every 3 years you recertify and you put your number in again. So I'm seeing across the country a tendency for companies to decide to try to just get it there by the time the next time we put it in goes. Like, it wasn't knowingly false when we put it in. Now we know it's false, but we're not actually putting it in. So I have no patience with that, but I know there will be people who will contend that means it's acceptable. And then the third type is a knowing failure to timely report a suspected breach or a cyber incident. And that goes along with the new rules from the SEC. And these are trickier cases to me. A breach case is advantageous in that the damages are maybe more easily calculated, maybe. But a breach case is, now we know it's already out there. I'm trying to bring cases to the government where we can stop it before it happens, where people are not in compliance, who need to need to get their ducks in a row and their house secure and protect the information from the government. So all of that as background, I would say that there's been 4 cases under the Civil Cyber Fraud Initiative. The first one was that Aerojet Rocketdyne, which was actually filed in 2018 before the initiative was announced, but ultimately was intervened and settled by the U.S. after the announcement of the initiative. There's been 3 or 4. Verizon is one.
Mhm.
Where Verizon self-disclosed, and because they did, they received a cooperation credit, and I believe their multiplier on damages was just like 1.5 instead of the times 3. So there's a really good reason the Department of Justice does try to work with people who come forward and self-report. Um, there are 2 cases that are in the public domain that haven't settled yet, and they're both mine. One of them is U.S. Rel Decker versus Penn State, and that is pending in the Eastern District of Pennsylvania. The other is Koza and Craig versus Georgia GTRC, which is Georgia Tech Research Corporation, an arm of Georgia Tech that is not a public entity that handles their grants for to way oversimplify the situation. So that was actually unsealed last Friday, a week ago today. So a week ago today was unsealed on February 20, whatever that was. And the government asked the court for 4 months to file its complaint in intervention, which is a normal step of the process. And so they're not issuing a press release at the intervention stage. They're waiting until their complaint and intervention comes out, which will say it will be formulating what we complained about as relators with what they've discovered during their pending investigation. So those are the 2 that are out from under seal. Decker was unsealed. In my opinion, prematurely. The judge gave the government only 7 months to investigate. And I guess we could back up a little and say that when False Claims Act cases are filed, they're brought under seal.
So what does under seal mean for the non-legal folks?
Good question. So sealed means that the only people who know about it, and in the court system, documents can be sealed, transcripts can be sealed, particular motions may be sealed, and it means only the party filing and the court knows about it. That's a complete seal. Well, FCA cases, the entire case is under seal. So if you go into Pacer and try to find the cases that are sealed, they're not there. They shouldn't be. Nobody knows about them except the United States, who is the complaining party, the relator who's brought the case, and the court. And then the court is in charge of giving the United States Department of Justice extensions based on good cause shown. So the statute gives the US 60 days to investigate, which is exactly the right amount of time to get a team together. Maybe enough time to interview the relator, but there's not much else that can happen realistically in 60 days from the day of filing. So pretty much pro forma, depending on the court, you'll get a 3 month to 6 months to even a year's extension right off the bat for the government to go ahead and start doing its investigation. Some judges follow that very closely and they want a hearing every time there's an extension. Some judges are less supervisory about it. I've had cases, the longest case that I had under seal was under seal for more than 10 years. Um, the cases more typically these days, my average, I would say, is 2 to 3 years from filing to a resolution. I would love for that to be faster. I think it would take some restructuring of how they're done. So I don't think that the way to cause that to be faster would be to go in and tell them they had to just do it faster. They're going to either need more resources or we're going to have to rethink how the cases are investigated with the client agencies. But when you just think about law itself is slow, and the Department of Justice is the lawyer for the client agency that's being ripped off. And they've got to go back and, educate the agency on what's happened, find out whether the agency thinks that really is a violation or whether they consider that a loophole that they're trying to fix through regulation. There's a lot that until you have that contact with the agency, you don't even know if the entity that's been defrauded thinks it's been defrauded or not. And
Does the defendant know that it's under investigation when this starts?
no, it's sealed from the defendant. It's sealed from the rest of the world. The first inkling the defendant gets typically is once the department has put together the team who'll be doing the investigating, which is usually an assistant U.S. attorney from the district where it's filed. So maybe Middle District of Georgia, maybe Southern District of New York, wherever you've actually filed. Um, There'll be a person assigned at Main Justice who may be very involved or maybe just simply monitoring the case, depending on a lot of factors, but always the size of the damages is critical to that. And then there'll be usually an investigator, maybe more than one, assigned from the home district. They'll usually be, if it's medical, which is about 85% of QUITAMs are medical in nature, then you'll have an HHS investigator assigned, maybe an HHS attorney. They may just go through DOJ. You can wind up with, in a defense case, you can wind up with alphabet soup around the table. You may have Army CID, you may have NCIS, you may have um, AFOSI, all kinds of folks around the table doing the investigation. And that all those, once they have that team together, what agencies are involved, and of those which are interested, they'll convene an interview with the relator. It's like a friendly deposition. It's not taken down like a deposition, but it's an opportunity. They've told their story to me. I've translated it into legal speak and tried to do a roadmap for how I think the investigation would proceed. Then they get a chance to ask in a game of telephone, right? To go back and say, so Leslie, your lawyer said X. Does that mean, B or C? And sometimes it's, I've introduced confusion. Sometimes it's just I didn't think about that question, but we spend, the better part of a day going through with each relator what the allegations are and what they personally saw, how they could attest, what they could attest to if it did actually go to litigation and at trial, what they would be deposed over, what they would, and that is an important meeting because it's a chance for the Department of Justice to assess the relator from a witness standpoint. Um, the case is ideally never built on just what the relator says, right? There's going to be other evidence. I like evidence better than witnesses anyway. But in a statute where you have to prove that it's knowing, that state of mind requirement, that scienter requirement, when that's there, that's where relators are so crucial because a company can formulate a defense. I always say the first defense is we didn't do anything wrong, and the second is if we did, we didn't mean to. And getting into the we didn't mean to is harder if you have an insider who was present, who knows you fully considered and how to do it, or they told you you can't do it this way, and they did it that way anyway. That type of evidence is crucial. And having a relator who is credible, well spoken, can, and people who are very truthful are not always the best witnesses. They can be very truthful, but hard to keep on target. And this is all something the department will be assessing in that first meeting. I prep my relators and explain what we're looking for. And we spend a lot of time getting ready for that meeting. It's not going to make or break the case typically, but it is an important, because the case is not about the relator. The relator's just a glorified witness, but it is an important meeting, and it's important that we are forthcoming with the department, that we tell them good, bad, and ugly about the case. We don't want to hide. You don't try to hide anything from the Department of Justice, right? You want to be very clear about that. So at
But
least
do you think the witness influences if they decide to take the case or not?
I think yes, but in a very intangible way. I don't think in a case where there's been, patient harm or um, public safety is threatened, where it would ever take a it would be the tail wagging the dog, right? But I think in the closer cases, figuring out there's always, do you believe the relator? And if you do you believe what they're telling you about what happened internally? Everybody views things through their own filter, right? So that's part of my job, is to figure out if how much filtering has gone on about what the relator has seen. And I try to tell companies, when I speak at places, speaking to industry, I try to urge them to be cognizant of the fact that whistleblowers come in a particular type. They're squeaky wheels. Their managers are often sick to death of them. I say they would call them stubborn and irascible, and I would call them dedicated and determined and self-referential, right? But there are certain people that you could save yourself and your company a lot of money if you sat down and explained to them why their understanding of the regulations is not correct. And sometimes we get those people. We get people who really, they firmly believe the company's doing it wrong, but they're just mistaken. And I would just as soon not have to explain that to them. I would love if people, I don't want to bring that case. I'm not interested in bringing a case for a case's sake. We want to find a situation where someone's really being hurt. So talking with your people, being transparent as you feel you can be with the squeaky wheels who are surfacing yet again. And these usually, they've been surfacing several times before they ever get to me, and making them feel that you're taking their request seriously, where their direct manager is likely to want to just say, shut up, Bill, we've heard enough out of you. And that's what they'll come back and tell me. And I won't have any insight into why maybe there's a better interpretation of the regulation in question than the one that my relator is bringing to me. That makes sense.
Mhm.
I'm kind of going on, and I feel like I'm
Yeah,
on.
no, this is good because I'm trying to get a sense of like a potential whistleblower who's watching this, what can they, expect in the next step? So by the time they come in for this like proffer session essentially and tell the government everything that they know, at what point does the whistleblower have to worry about their employer knowing if they still work at this company? When does the company find out, the
Yeah,
defendant?
it's a great question. So it's not right away. I started to tell you the first inkling that the company usually gets is once that initial relators interview has happened. Some of the information we provide is like, who are good people to talk to, who could corroborate what you're saying, and what documents would, even if my relator has a copy of a very important document, the government's going to want to get a copy from the defendant, right? They want to show that there's no arguing about whether it's been doctored. This is your document, right? So they will often do what's called a civil investigative demand, which is a basically government CID, a government subpoena. And the U.S. Attorney's Office can issue those themselves, and you'll get, dear Company B, send me the following documents. It'll look a lot like a subpoena. Usually the company will then, now at that stage, those can come because of a self-initiated FCA action that the where maybe just DOJ is looking into the company. There may be no relator, there may be no case filed. Um, it can come for routine audit. It can come, you don't know from that there's anything except a government investigation. But often at that point, the company will engage outside counsel to directly work with the government. Um, the government will start to call witnesses, and they usually move from the outside in. So people who are no longer employed, who can be talked to without any worrying about if they're in the control group as far as privilege goes or anything like that. Um, when they pull the trigger on calling live people, because once you start talking to people, the odds of it getting back to the company, are exponentially increased. So when they start doing that, that depends on a case by case basis, and the preference of the U.S. attorney, the assistant U.S. attorney who's overseeing it, how aggressive they are, the kind of claims we've got. how fast the judge is going to pull the investigative period. All of those have to play into, which way they go with their investigative tools. But there'll come a point where the government will actively want to actively engage with the defendant, assuming that your allegations are being corroborated. So, and I'll say sometimes they're not corroborated, not because the relator got it wrong, but because there's something the relator just didn't know about. Anything that undercuts that scienter component, I've had many cases that fell apart because the defendant had gotten permission. I like to call it a get out of jail free card. Maybe they went to their contracting officer and said, how the contract says X, well, we're going to do Y. And the contracting officer may not have formally signed off on that, but knew it and continue to make payments under the contract. Well, I can't really call it fraud if that pattern and practice has been going on for so long. So it may still be something that someone above the contracting officer level may choose to remediate and say, no, we're not doing it this way anymore. And then my job is done as far as feeling like we're protecting the health and safety of our troops. But at the very least, you're making sure it gets vetted by those in authority, right? But you can't call that fraud. When their liaison is the contracting officer, when they've cleared it with the contracting officer, the FCA angle kind of goes away. Not the retaliation angle, and potentially not the attorney's fees angle, depending on how much work, has been done on the Quitam versus retaliation and that sort of thing. But the bottom line is, at some point, the government is going to want to talk to the defendant about what's going on. And when they do, they will ask for a partial lift of the seal. So that is not when I first heard that, I thought that meant the seal was like lifted in part. It really is a lift only as to specific entities. So they will ask for permission to disclose the existence of the quitam to the defendant. And they don't usually start by disclosing the quitam. They start by saying, yes, we're investigating an FCA case. They might say a quitam. They don't tell them who the relator is, and they don't give them a copy of the complaint. So in a tiny office, that may immediately go, aha, it's Leslie. In a big company, they may have no idea who it is. And what I typically encourage relators to do, not every time, but typically I encourage relators to start looking for other employment while we're going up through all of this process, because from the time that I speak with them to the time we file, maybe a couple of months, depending on how detailed the allegations are. And then from the time we file until the government reaches this stage is probably maybe a year. So it's plenty of time to try to get securely in another company, let them get to know you before anything like this becomes public. That's kind of an ideal situation. It doesn't always work that way. Sometimes there's reasons why we want the relator to stay where they are. If where they will hear things in the ordinary course of their job, they do not do spy work at all. Once we've turned it over to the government, then it's like that fruit of the poison tree you see on Law and Order. You're not allowed to do anything that the government couldn't do. So you can't, for example, take things from a desk but in the ordinary course of your employment, if you're, given an email that says not anything privileged, but company information, then you will share that with the government. We'll take that back and we'll do it as an update. So at that point, sometimes they know who it is. Sometimes they're still not sure. At later points, if they continue to negotiate, usually the U.S. will do a presentation that says, you were quite naughty and here's how much you owe us. And then the company will say, we were not at all naughty. And if we were, we didn't know. And if we did know, it's not that much money. And then the kind of negotiating will start. They will have a very busy season where they're going through looking at each other's evidence, and then they'll go apart for a while. They'll come back and they'll exchange information and maybe numbers again. And then, in an ideal world for us, they reach a settlement. They typically reach a settlement before they intervene. So you'll get a notice of intervention and a notice of settlement on the same day. In some cases, and they're really not that many. That's why it was exciting in the Georgia Tech case, because they're intervening, they're not settling, they've not reached any settlement agreement. I don't know whether they will in the 4 months that continue. The judge gave them no more time. So they had to intervene or not, and they intervened, which is terrific for our clients and us and the taxpayer, I feel. maybe they'll reach an agreement before the 4 months has passed. Maybe they will continue. I'm not even speculating. I'm just giving you the avenues that it could go from here. But typically, an intervention is accompanied by a settlement and a dismissal. Um, I wouldn't. I'm not sure about percentages of that. Well, more than half. And then sometimes they intervene and say we're going to be litigating this, and then they take the route that I've already referenced, where they're coming up with their own complaint and intervention, which will be filed with the court, and then it'll take off.
They write their own separate, not the quitam. They won't take that complaint. They'll
They will
rewrite.
use that. That's usually the basis of it, but it'll be their own complaint because now instead of they will have learned things through the course of their um, investigation. They'll know things by virtue of being the government and not the relator. So, and then they usually include claims like unjust enrichment, which is some more common law claims that are even if you didn't defraud us under the FCA, entitling us to treble damages and civil money penalties, you at least have been unjustly enriched. And so, there's some other theories that get added to those, typically get added to those complaints and intervention. And then that would just go like a regular litigation, mostly with relator kind of writing second chair on what the government's doing. And we help a lot. There's been cases recently, a trial in Minnesota where the U.S. and the Relators Council tried it jointly. That's ideal because you get, relators resources. That's the whole idea of the FCA is relators and their counsel as private attorneys general to help the U.S. with resources. So we can contribute not just the relator, but our expertise in the law, our willingness to do, help with briefing, and of course, if we want to bring in experts, if we want to, hire experts to, which often is necessary, if only for damages, we'll be bringing those in.
So with the Decker case, there's been a lot of not speculation, but people have misread, I think, the headline that DOJ said there's no decision at this point to intervene or not. So can you talk about like that? Like what did that mean, and what does that mean for their chances of intervening, I suppose?
Sure. So with respect to the FCA generally, instead of just Decker in particular, it's very, I told you, there's no real standard for how much time the US is going to get beyond the 60 days. And I'm seeing a trend with newer judges in particular. They're willing to just say you got to do it faster, and they'll cut off that time. And sometimes the government is able to scramble and make a decision in the time that they're given, but more often than not, they can't. So it's hardly the first time it's happened to me. It's called a demi declination because what they file to the court says we have to give an answer and we can't. We don't know. We don't know if we're intervening. That's what they say. And because they don't intervene, they're taken to have declined, right? Because the court won't let them just sit there. The court is going to treat that as a declination, even though it's not. That usually, you get 90 days to serve the complaint once it's unsealed. And during that 90 days, sometimes they're again scrambling to finish their decisions. Sometimes we get to the 90th day, we get not really to the 90th day, but sometimes we get to the point where it's service time and we will serve, and that gives them 60 days to respond. And so again, during that's 2 more months where something might shake loose with whatever the government was trying to be certain on before it made a decision. And then I've had it go all the way through, summary judgment where the U.S. has never intervened or declined. The heat is off for them to be working on that case once they file the demi declination. So it's kind of how much resources do they have to devote to a case that is not on their docket while they're getting pressured to deal with the ones that still are on their docket. So it's not in any way ideal, but any time that we're asked as relators counsel, what do you think about this, giving them more or less time, I don't want a case that's declined without a robust government investigation, right? I just don't have the statute and the infrastructure, the whole system is set up for Department of Justice to go to its client and make decisions about big policy decisions well above my pay grade, and I don't want to launch a litigation in declination and find out that the agency that I'm saying was harmed takes the position it wasn't harmed, right? That's ridiculous. And I can be very deferential to what the agency believes, but not if there's not been that robust investigation for them to decide whether this is something they want to go forward with. So never would I like. I know there are relators counsel who disagree with me, who want to see the government's feet held to the fire, and I think they think maybe that would cause the necessary change for things to move faster, and perhaps they are right. But on a case by case basis, that's the last thing I want, is for the government to get its rug pulled out from under it in the middle of its investigation. They're not, they're just people doing the best they can with big docket loads. There's plenty of fraud to be investigated. Um, so with Decker specifically, our judge gave us, like I said, I think 7 months from filing, not even a whole year. And this isn't a routine medical case or a simple contract issue. This is the first cyber fraud. I mean, there are the last what I've heard DOJ say several times is dozens. So we're not at to hundreds, but there's dozens filed. They're still working out expertise in this area. Nobody before the cyber fraud initiative, we didn't have folks like you, Leslie, who understand cybersecurity. I cheated a little bit because I've been the plus one to a lot of cyber fraud events with my husband, who's a data privacy guy, former IT guy. So I got up to speed, if you can call it up to speed. I became much more up to speed than I would have been if I hadn't spent a lot of time in this world. And we always joke that I kind of got a double major and ironically, he went to Georgia Tech. So I spent a lot of time in Georgia Tech's Rich building while we were in college. So, needless to say, I'm sure there are some people like me at Main Justice who had some expertise from their background, but it's not what you're expecting as an FCA attorney to spend a lot of time understanding the NIST controls, and how to conduct a cyber audit. So to get confident enough in that space to make an intervention decision is pretty challenging. And in 7 months, that's crazy. And so what we did is all the parties, the defendant and my relator and the U.S., all agreed to accept magistrate jurisdiction. So we were moved over to the magistrate judge's docket, and we asked for a 180-day stay of the case to allow the U.S. to finish its investigation, and was granted. So we are in we're like in investigation light, I guess, in that it's out in the public, not not talking about Decker in particular, but in general, I would assume a company would rather not have the investigation conducted in the public light either. It's all these allegations and speculations are going on, and they're not really able to defend themselves. It's not active litigation. It's not really ideal for anybody, but that's where we are. So this had been done once before in the Eastern District of Pennsylvania with another FCA case, and we're in front of the same magistrate. And I think there were 380-day stays to get it resolved in the other case. I have no idea whether we would be looking for another extension. And I know the people in the Eastern District of Pennsylvania are working diligently on the case. I had a call with them yesterday. It's not the timeline's being taken very seriously, but it takes what it takes in these cases to reach a policy level decision. And with the cyber fraud initiative, it's got to go all the way up the chain at Main Justice because it's a case of first impression, so to speak. There's no internal policy on how we're going to do certain things. They have to really vet it and come up with their procedures. So I'm sure that's a big part of what takes time. And I'm not sharing something they told me. I'm just speculating based on years of experience in the space.
Why do you think the DOJ was able to make a decision? Seems sooner, right? Because it's just now unsealed, and we're just now hearing that they're intervening, whereas Decker is unsealed and they haven't decided. So is it just because of maybe who was assigned to investigate from DOJ, or is it where it was filed maybe?
So that's a hard question, and I don't know. I'll tell you some factors that are surely at play, but I can't say which are more or less important. We do have a different team of attorneys on each case. From the justice angle, I have a different Main Justice attorney on both files. In the Northern District of Georgia case, Georgia Tech sits right there in the Northern District of Georgia, and there had actually been another investigation and a grant fraud case with Georgia Tech. So they kind of been down that path together before. With respect to the, I guess you could argue I should have filed in the Middle District of Pennsylvania, the Decker case. Most of the Penn State campus is Middle District rather than Eastern District. But for a lot of reasons, I chose to file it in the Eastern District. So there may be some of that at play. There's the fact that they have two different sets of attorneys for the defendants. And, I think the tact that the defense attorney takes can be anywhere from let's try to get this resolved to let's try to make this go away and everything in between. And when you take a make this go away tact, you're spending time trying to say we didn't do anything, and if we did, we didn't mean to, and you're not focused on that resolution piece. By contrast, if you're focused on getting to a number and a resolution, you can do that a lot faster. I have very little transparency into those discussions and investigations, and to the extent I do, I can't share them. But all of that would play a factor in how fast it goes. And I will say, Decker getting unsealed quickly ahead of the Georgia State unsealing might have put everybody into a fast forward mode that would have helped the Northern District people, because it's at main justice, if they're, like I said, they're having to set policy decisions. How are we going to handle X? What do we take about Y? For the type of cases those are, you've got the Spurs scores. Are you gonna, and each they upload an SPSS, their plans and
Oh,
their
SSP, the system.
SSP. Thank you. I really should have my acronyms tacked everywhere. I'm still learning this stuff. Their SSPs, what if they have one, but it's how bad does it have to be considered not having one? Right? That's something they're going to have to decide what they're willing to litigate. Are they going to litigate cases? Are they going to? It's like with medical care. We went through it with the nursing home cases years and years ago, where if a nursing home provides bad care, that's not no care. How bad does it have to be called worthless services? And you're going to go through those same types of analysis with cyber fraud cases, and it's going to take some time. And different districts may reach different conclusions, because this is a initiative coming out of Main Justice. I think it'll maybe be more coordinated than some of the other things that have happened in the FCA. But even so, you may have different decisions made uh, within the same spectrum of whatever the department decides. So again, this is Julie's opinion, and I have to give the disclaimer the government people do. I'm certainly not speaking on behalf of the Department of Justice. I'm really only speculating with you, what may be happening. But that would be a big reason why, if they see that they're having to move super fast in EDPA, why they would already be, that would benefit other cases across the country, including Northern District of Georgia. So again, I wouldn't draw any conclusions at all from the fact that they were able to make the timeline in. And keep in mind, Georgia Tech was filed before Decker, and Georgia Tech was unsealed after Decker. So they did get a substantial amount more time than the Decker folks did. And so although they made their decision faster in that they didn't have to file a demi declination, they had more time to make the call. So I would say nothing bad about EDPA based on that. And I love my Northern District of Georgia people, but they did have that advantage. So
Yeah. So I guess the only constant is change, or the only thing consistent is inconsistency in kind of this black box process. Is there anything else about the False Claims Act that we haven't talked about that you think is really important, either from a defense contractor perspective or a federal contractor, or maybe a potential whistleblowers? What should potential whistleblowers know, or not do, or should do, if they think they're in this ethically black or gray area where they, think they might be witnessing something wrong?
sure. I think they should get good counsel, and I'm not just me, although I'm happy to talk to anybody. It's I looked one time years ago, and there's very few plaintiffs' attorneys who don't put whistleblower on their website. That doesn't mean they know this space very well, and it's really foolhardy and risky to take a case to somebody who doesn't know the actors, even down to who, I mean, I can, because I've been doing this and only this for so long, and there are others like me, to be able to know what's the best district to file this particular type of case in. Maybe because you know what they're already doing, maybe because you know where they have some expertise. A lot of the defense contractor cases could be brought anywhere. There may be some natural tendency to bring it where the headquarters is, or where the manufacturing is happening, where the relator is, but all of those are things to be thought about very carefully. It's also the case. So I like to give a nurse example. When a nurse is trained, they're trained in safe harbors, right? So if you're working in a nursing home and you're told that you write down the medication when you give it, you don't write it down later, you don't write it down before, you write it down exactly when you give it. That way the medical records are maximally integrate, right? This is how we know there's integrity to the medical records. So suppose you're giving Mr. Smith his medication and Miss Jones down the hall codes, and you're called down to her. Now you've given him the pills, you haven't written it down. Life or death, you run down the hall and you help Miss Jones. Afterwards, your director of nursing says, "Oh, Leslie, you need to write down those meds that you gave Mr. Smith." And you say, "I can't do that. That would be fraud." Right? Because when you're trained, you're told writing down medications you didn't give is fraud. The safe harbor, the safe thing to do is do it right when you do it. As you and I both could tell, that's not really a False Claims Act case. The guy got the medicine. You didn't, you gave it to him promptly and timely, and you're just simply documenting what already happened. And the reason I like this example is because the nurse who's been trained on the rule, on the safe harbor, believes that the safe harbor is the rule. And she's not really in the position to say, are they really asking me to, the call I get is my nursing home wants me to commit fraud. And I have to unpack that and see, well, why do you, what exactly were you asked to do? Well, did he get the medicine? Is this, and that's where I think, I love doing intake. I do it all day long because it really, what you want to leave that conversation with is either you're right, this is fraudulent and we need to let people know, or you're right, but this isn't something you want to undertake. I don't always suggest, depending on what the fraud is and the person's circumstances, they may not be the person who needs to bring that up. Or, I just had an intake call this morning where what the person would really like to do is de-escalate the situation and go back and try to get them to do it right. No doubt that she's right about what they're not doing, and no doubt in my mind, uh, and that she believes it. And knowing what I know about, this is this is actually a defense procurement case. Knowing what I know about procurement, she's right and they're wrong, and they're trying to get her to hush. But they might be trying to get her to hush because of the very noisy way she went about it. And if she could kind of back that down, and they might fix it. And I'd rather her fix it. I really would. If uh, sounds silly as an FCA attorney, but our goal, Jason and I founded our firm saying we wanted to do well by doing good. And sometimes to do good, it's not filing the FCA case. So I really hope that relators, potential relators, people who are struggling with this, we got you. We know that's what you got to worry about, is what's the best thing to do. You need counseling more than you need an attorney to start with. You need the counseling part of the attorney role. So we find a counselor who knows what they're doing, who can help you figure out if this really is fraud, and if it is, knows the right steps and the right people to get it in front of the right part of the government to see that the right thing happens. That it's a lot of rights for one sentence, but that's our goal. And I think that's tremendously important. That speaks to what defendants, potential defendants, should be doing. Talk to your would-be whistleblower. I have my little presentation is called "The Care and Feeding of a Would-Be Whistleblower: How to Never See Me Again." And it would be lovely, if I worked myself out of a job because nobody was defrauding the government. I don't have any real fear that's going to happen anytime soon. So when where we can help straighten it out, that's what, that's always on the table. But a lot of times by the time they get to us, we know that's not on the table, and we're prepared to, draft it up and move aggressively if that's what's appropriate.
Yeah, no, that's great because I was then going to ask you what advice do you have for contractors, but it sounds like, talk to your whistleblowers and
Yeah.
so,
As transparent as you can. There are reasons why I know particularly like privilege. Let's say someone complains about a practice, and then you consult with an attorney, and the attorney tells you, no, you're right, you're doing fine, and you're worried about disclosing that privileged information to a lower level employee. Maybe you just say, I love it. It's happened before. It's not very common, but I have had before where they wrote it out for the complainant. This is what you complained about, and this is what we did, and this is the resolution that we reached. And by golly, that person still showed up in my office going, they're doing it wrong. And then I could read the thing and say, I agree with them. This is a closed question. Maybe the court would disagree, but it's a good faith basis, and that's enough to make it not fraud. Because we're going after fraud. We're not going after people who take advantage of loopholes that exist. We're going after fraud. So,
yeah, no, that makes sense. That's awesome. So
mhm,
those are all the questions that I have.
terrific.
So yeah, unless you have anything else you want to put out there, or if you want to hype the fraud coalition that I know that you're.
Oh yeah, the anti-fraud coalition, not the fraud coalition, the anti-fraud coalition used to be Taxpayers Against Fraud. That's the Quitam Bar, and that's another place to go for good information about this process. If you go to our blog, our website is FCA, as in False Claims Act, FCA Counsel, COUNSEL.com. We have a blog that covers a lot of these topics. We try to walk people through what to expect in the process, and we are 24/7. You can go there and reach one of us, one of our attorneys, to be glad to walk you through, me or somebody else, or me and somebody else, to walk you through kind of what we think about what you're dealing with.